Hello and welcome. I'm Ashwin Mohan and you're watching The Law Street, presented by Legal League Consulting in association with ET Now. In today's episode, we will dissect two key policy measures from the government that will change the rules of the game for India Inc. The Insolvency and Bankruptcy Code and the Real Estate Bill, which became an act earlier this year on May 1st. We will first address the Insolvency and Bankruptcy Code, and to throw more light on this landmark reform, we are joined by two leading voices from the world of corporate law, Krishnava Dutt, Managing Partner at Argus Partners, and Alok Dheer, founder of Dheer and Dheer Associates. Gentlemen, thank you so much for taking out time and joining me on the show. For starters, can you both give a quick overview of the code? How does the framework help towards repairing impaired loans in a speedier manner? Krishnava, if you could start with you.
If you just walk down the regulatory history and see what we had from a legislative perspective was, of course, after the SICA 1985 came, DRT in 1993, which actually implemented only in 1999 by the time the DRT Acts came out, because the diagnosis was that the courts had an overburden of cases and that's why they needed a new tribunal for that. But by that time, they realized the diagnosis was wrong. It was the issue was more systemic and not just a court overburden with cases, but something larger. And the answer to that was a SURFACI in 2002. The SURFACI also was in three pillars, which is the securitization, the asset reconstruction, and the enforcement. But what happened over the years, the securitization happened as a part more than recovery, as a capital release process. But the enforcement really was in fact effective for some time, till such time it realized the enforcement was only with dead assets and dead real estate assets.
All right, now that we have introductory comments from Krishnava, Alok, if you would like to add to what he has said regarding how this bill in fact is a game-changing aspect as far as the bankruptcy regime in India is concerned.
The problem in India has been that over the years, as Krishnam has rightly pointed out, there have been various enactments and they have been addressing certain parts and parcels of what are the overall problem that the country is facing. We currently have some 9 trillion crores of stressed loans in India, and our recovery rates are very, very poor. We are recovering about 25% of the amount due to the banks and financial institutions, and time for recovering the money is about 15 years for the bank. Even the winding up takes about 4 years. So as Krishna rightly pointed out, there is a broken system. The system's not been working. IBC is perhaps the first attempt at a most comprehensive approach to restructuring and leading to insolvency, if I may say so. And this is based on a certain completely new architecture for insolvency and bankruptcy in India, and complete structural changes have been put in place. Primarily, the three basic structural changes are that we have now moved on to a creditor in possession regime against a debtor in possession, which was the SICA. Secondly, rather than the legal and judicial wisdom, it is the commercial wisdom which will now implement the enactment, and the creditors will apply their minds to see whether the companies can be rehabilitated or must be taken into winding up. And to put this all in place, we have completely new infrastructure which is being put in place, which is resolution professionals, information utilities, and forums for adjudicating like NCLT, DRT, the board, the IBI, Insolvency and Bankruptcy Board of India, and the NCLAT. The whole purpose for doing this is that we've had too many laws. Incidentally, the IBC repeals 2 and amends 11 legislations. They want to put in a time-bound process. They want to maximize value to the creditors, bring predictability to the system, which will end up promoting entrepreneurship, availability of credit, and create a robust debt market.
You brought up the issue of infrastructure, and in fact the key to the success of this code, many believe, lies in proper implementation, and proper implementation is definitely not possible if it's not backed by proper infrastructure. And in this case, of course, one needs to have insolvency professionals, one needs to have information utilities, one needs to have tribunals. So therefore my question is, what's the time frame in which relevant professionals can be tapped for this code and such infrastructure be created? And isn't that time frame a little uncertain? Krishnava, if you would like to add to that.
The key would be the insolvency professional here. And there are also the other infrastructural issues like the DRT, like the NCLT, We're not sure because DRT anyway has been bogged down by an overburden of cases anyway.
And Krishnava, the other problem would be, is there a ready-made pool of such professionals who are adept and who are well accustomed to take over this role of being an insolvency professional in the first place?
So I was very curious. So I said that who would be the people? Would it be, I don't know whether they would be advisors, someone from the big fours carving out, or there would be the other restructuring companies of the world coming in, or whether the ARCs, the other is about ARC, people who promoted ARCs will suddenly, so it's a guessing game. It's a guessing game. We're not sure. I've had yes and no's from both sides. I've actually been curious enough to go and speak to quite a lot of them. In terms of pool of skill sets, I guess advisors, people who've been in restructuring, people who've been in insolvency, bankruptcy, special asset management, those would be fundamentally the people. Special situation fund managers, these are the guys who would be coming in.
Alok, would you like to add over there? Because it's clearly going to be an issue to tap relevant professionals. And because if the relevant professionals are not tapped, then these institutions are not going to be manned properly. So do you see that as an uphill task for the government going ahead, Alok?
Ashwin, I think it's a very uphill task. I would imagine that infrastructure building and capacity building should precede enactments of this nature, because the enactments can completely come a copper if the capacity building is not there. Now, insofar as resolution professionals are concerned, there are lots of initiatives which are being taken in the country today, and there is a lot of people are coming up with setting up insolvency agencies, or at least planning to set them up. I'm sure some of the big four will be doing it, and some advisories and consultancies who are operating in the special situation space will do it. But primarily the government seems to be thinking that the pool of talent which is available, in as much as chartered accountants, lawyers, company secretaries, ICWAs, and people from the management background who have been operating in special situations and distressed assets would come forward.
In fact, now I want to get into the all-important insolvency resolution period, which is 180 days, or plus 90 days, which is amounts to about 270 days, but that's only in certain exceptional cases when an extension has been granted by the relevant authorities. Krishnava, is the time frame sufficient? And do you expect any sort of challenges when it comes to settling cases within this time period?
So in a simple way, no. I mean, we can't see in 180 days, but I'm not sure whether that's a hard stop 180 days. I mean, it is intended to be by the legislation. It says that 180 days. What if not? There would be extensions, and I think the critical point is the intent behind it. And 180 days is directional to set the tone of the resolution to be in a timely, time-bound manner. It should be respected. Of course, it's legislated as 180 days, but I do see a lot of problems coming over that, because that 180 days start, out of that 30 days is the interim insolvency professional, and then from that another period. So I really don't think within the rabbit comes out within 180 days, but surely, I mean, that, as I said, it just sets the tone, and probably people, if it evolves, it may be, as he said, that probably the most important is the integrity and the efficiency of I mean, that's the key to this whole legislation, that we must have the infrastructure in place before that.
Absolutely. So clearly a step in the right direction, but there could be certain practical challenges on the ground. Alok, now I want to look at this entire bill from an investor's perspective. Do you think it will provide distressed asset investors a much-needed platform to access distressed investment opportunities in a transparent, reliable and time-bound fashion? And also, how is it going to be beneficial as far as ARCs and the lenders community is concerned? Because the lenders community is now beaten down with poisoned balance sheets.
Everybody is looking at this enactment from the perspective of change which was required to be brought into the system. The investors, the creditors, the private equity, the ARC, all of them were in a position where they were not clear as to what is going to happen and how we are going to recover money, whether the resolution process will work through the BIFR or not. Now, what this act seeks to address is, it puts a timeline. It says 180 days. Try to set it right, try to do a restructuring, and if a restructuring doesn't happen in 180 days, we'll go down the liquidation path. So the idea was to give predictability and a timeline to the system, and not to extend the timeline from time to time.
Time now for closing comments, and I want to address two very crucial issues. One is definitely going to be, what are the lessons that India can learn from overseas jurisdictions, because the bankruptcy code is not something unique to India. It's been tried out in overseas jurisdictions also. Every jurisdiction, of course, has its own peculiar ground circumstances. So therefore, Krishnava, I want to ask you, what are the lessons that the government can learn? And could you illustrate how the experience has been in some of the overseas countries?
Like India, the usual average recovery is 25 cents to $1, whereas in an OECD country or UK or Singapore is as high from 70 as an average or a mean to even 90 cents to $1. Time period taken in India, as Alok said, it takes probably much longer. Why India? Even Southeast Asia. And the third part, which is very interesting, which I said why SARFAESI didn't work probably or work well enough, is because everywhere where the numbers are low, where the insolvency law is not there, we see there is a binary that in terms of countries where there is no insolvency, the enforcement is through dead asset sale, where really half the value, 90% of the value of the assets are gone before you can enforce it. Whereas in jurisdictions which has a robust insolvency law, there really is mostly a going concern sale, where you're talking about the M&A aspect of it.
All right.
So that's where it is.
Alok, I'll leave the last word to you. What kind of an impact do you think the new code will have as far as deal activity is concerned?
I would think that there is a provision within the enactment of bringing in the resolution plan, and the resolution plan can actually be given by anybody. It could be the information memorandum is to be prepared by the insolvency professional, and on the basis of such information memorandum, any third party can come in for an acquisition, takeover, amalgamation and merger. So there would be a lot of information available in public domain with respect to the financials of the company and operational information, and that's where the hope rests, that we would have credible promoters and incoming funds and such other entities who would be interested in reviving companies coming forward for this purpose.
All right, on that optimistic note, we have come to the end of this segment as far as dissecting the new bankruptcy code is concerned. Krishnava Dutt of Argus Partners and Alok Dheer of Dheer & Dheer Associates, thank you so much for taking out time and joining me on the show. But